This is another amazing time that we have for our intellectual engagement with the matters of law and what is the matter with the law. Today's meeting of minds is about the doctrine of Prima Facie. Prima Facie has been in the use for quite a long period of time by lawyers, judges, law professors, and legal scholars. However, what is the meaning of prima facie and how is it used in our legal system in Kenya today? It is a question of the meaning. Prima facie comes originally from Latin, and it means prima means first, facie means appearance or experience or impression. So it is like the first appearance. However, still, it is more complicated than what it appears to be. We may not get to understand it without relating it to its own context, that is evidence. When we talk about the law of evidence in Kenya, it is an act of parliament that declares evidence, and that is found in chapter 80 of the laws of Kenya. Evidence denotes the means by which an alleged matter of fact and of truth is submitted to investigation in terms of being proven or disapproved without any prejudice to the foregoing generality of the accused statement and the observation of the court in its judicial capacity. Here we have talked about matter of fact. What is matter of fact before the court? What is fact? Again, back to Latin, again, back to the Romans. Fact simply means thing in a simple and basic matter. Anything, any action is a fact. Fact is anything, state of things, relation of things that are capable of being perceived by senses or mental condition of which any person is conscious. However, let us again go deeper and look at the concept of approval. The court can approve of facts or matters of fact before it, or disapprove such matters of fact. Approval again goes hand in hand with the existence or non-existence or the existence of probability towards the claimed fact. However, the law again makes us understand that a fact that is not proved is neither proved or disapproved. Again, we gather to understand the processes under which the court may approve a fact before it. And in this case, the fact must be truthful. It must have actually existed, and it can be declared an existing fact. In that case, the fact is approved. But if the fact first is not truthful, or it is not existent, or there is probability of its existence, then this may amount to its disapproval altogether in its entirety. However, the concept of prima facie appears to us as it is under the presumptions under section 4, especially subsection 3, in which if the law has declared a certain fact to be the proof, that particular fact in relation to other facts may not require another proof or another evidence in court. And that justifies the concept of prima facie in the sense that prima facie means that the fact as they appear are perceived or believed to be truthful by the court unless otherwise. And that is the presumption of the fact. So it is a question of if a fact requires other facts for it to be true or for it to be perceived as existing, or it is clear as it is. That means the truth is there and the fact is telling, and the Honorable Court may believe the fact as it is presented, and that is prima facie evidence, and we find it being deployed in criminal proceedings, in civil proceedings, as well as in administrative proceedings. The truth of the matter is, this lecture may be deferred for another occasion because it is very broad indeed. Prima facie duty in the law of tort is very broad and may also require our attention. Thank you for watching, and thank you for checking out on these videos, and also for the subscription, and put your comments, your remarks. I will be happy to look at them.